Thank you, and thank you for inviting us to participate. I am Pierre Davis, I'm Associate General Counsel of Broad Hill Financial. Two of our companies, S&P Dow Jones Indices and Platts, are benchmark providers, and together we are. Broad Hill Financial is the largest independent benchmark provider in the world. So we obviously have a deep interest in these issues and the regulatory work streams that deal with them. If any of you are not familiar with our products, some of our more prominent indices in the S&P Dow Jones Index space are the S&P 500. We publish the S&P Euro 350. We have a whole host of indices in other asset classes. We publish real estate indices, the Case-Shiller real estate index is widely followed for U.S. home prices. We have fixed income indices. We have a whole host of indices on the S&P Dow Jones index side, many of which are used for financial products of all sorts. On the Platts side of the house, Platts is the leading commodities benchmark provider. We have several extremely important price assessments that we publish, including the Brent crude index, and my colleague Dan Tans here is the head of editorial for Platts. He can explain in much more detail than I can the intricacies of our commodities benchmarks, but suffice to say that the Platts side of the house also has a whole range of price assessments, including oil assessments, metals assessments, gas, biofuels, etc. So the whole range. We are, as I said, very interested in this proposal in particular and the other regulatory work streams. We've been engaged and we've spoken to many people in the room, both on the policymaker and regulatory committee and also on the industry side on this proposal and its meaning to us. And we welcome the opportunity to continue to engage. I think one of the most important aspects of this entire process for us is the ability to engage in dialogue, to explain what we do, to explain the impacts that this proposal could have if enacted as it's currently drafted. So we welcome that opportunity. We also have been part of the IOSCO process in both the PRA principles for oil price reporting indices and financial benchmarks. We do obviously offer comments, but prior to the Labor scandal and the current regulatory work stream and the IOSCO financial benchmarks principles, we went through nearly a 2-year process with IOSCO and responding and meeting on multiple occasions to discuss the oil PRA principles, which Platts has now implemented. And we continue to believe in that process. In fact, we are going to take the oil price reporting principles and apply them per IOSCO's request, Committee 7's request when they were published across all commodities classes. And we think that those principles came to a reasonable place and caused a globally consistent approach. And you'll see later in my remarks, McGraw-Hill Financial as an organization is very supportive of a globally consistent approach and the IOSCO approach, both on the PRA principles and principles for financial benchmarks. As a leading benchmark provider, I take MEP Swinburne's remarks to heart. I know that she's going to stop on the street. I know other people are. We understand that the Labor scandal happened. We understand that there are other scandals which are unfolding. We understand that there's a lot of press in FX, in Labor, etc. One of the things I would say, though, is that the mere fact that a benchmark is questioned does not mean that anything was wrong with the benchmark or that any malfeasance occurred. I think if you saw the recent statement by Ofgem and FCA on natural gas in the UK, allegations were made in that instance, and no formal allegations or no wrongdoing was ultimately found. I think similarly, as you look at some of the preamble to the DC proposal, for example, it talks about recent allegations of manipulation in the commodities markets. We are subject, and it's no secret, it's widely reported, on the Platts side of the house, we are the subject of an inquiry by DG Com in oil and biofuels, so two of the categories that were mentioned. I would just like to mention, and I'm not trying to be defensive or otherwise, but I'll just mention that no formal allegations have been made. That was a notice of decision by DG Com. No statement of objections has been made, and certainly no finding of wrongdoing. And I would ask, I'm a U.S. lawyer, so I'll talk about U.S. constitutional due process. But I would ask that we not be sort of prejudged prior to any even allegation of wrongdoing, and the fact that you want to potentially, that the proposal potentially is going to reform an entire industry based on what I would equate to a subpoena, is food for thought for us certainly, and I think it should be for others as well. That said, we also are cognizant of our importance in the markets. We have a major role to play in world oil markets. We have a major role to play in other commodities markets. We have a major role to play in financial markets. There are innumerable financial products based on our financial indices and our commodities benchmarks. So we understand that. We also, though, think we have best-in-class controls, processes, and procedures. Many of the things that are talked about in terms of restoring the integrity of benchmarks, we do. Conflicts of interest policies, making sure that we don't have, we are an impartial, independent index provider. Our entire business is based on our integrity, and based on the fact that people look to our benchmarks to be an independent voice as to either the state of a given measured market, like the U.S. large cap market, or an independent assessment of what a crude oil price might be. So because of that, from a market perspective, from a competitive perspective, we are absolutely in a position where we have to have best-in-class compliance policies and procedures. And you have a guy, some American lawyer from New York, up here telling you we have a lot of compliance policies and procedures, and therefore everything's okay. No, I'm not asking you to take me up my word, because IOSCO asked us to demonstrate that we had that. And for example, in the IOSCO oil price reporting principles, we have just completed, E&Y has just completed the assurance review that was called for by those principles. And the publication, I haven't checked my email down, I don't know if you have, but it's imminent. The results of that audit, which I think will be hopefully comforting to many, are imminent. We also are undertaking a similar process in response to IOSCO's principles for financial benchmarks, which were published in July this year, and we are undertaking, and my colleague Peter Rothman is 3/4 of the way back in the room. We spend a lot of time together talking about how we're going to demonstrate alignment of the S&P Dow Jones Index business to the IOSCO principles. So we take those things very seriously, and there are very practical reasons why we take them seriously. One of them is, to just illustrate an example from the commodities world, if under the U.S. legal regime, if the CFTC, who is the relevant regulator, does not feel that the underlying interest in a futures contract is sound, and in many cases that would be one of our benchmarks, then they can proceed to delist or institute delisting proceedings. That is a significant deterrent and a significant motivation to having us apply the IOSCO principles. We think that's a very powerful mechanism, and that's one of the reasons why we have actually aligned our operations with the IOSCO principles, and we feel the same on the other side of the house as well. So those are real mechanisms by which regulators can already ensure. I'm sorry, I left out an important point. The CFTC is saying to the exchanges, to the market authorities, the way you can demonstrate to us that the underlying interest in the futures contract is sound is by demonstrating that they align to the IOSCO principles for oil periods. That alignment allows us, and it allows the exchange to say, this is sound, look, they adhere to the principles that you set forth. That, coupled with the fact that we are publicly going to demonstrate our alignment with those principles, we think provides a good mechanism. There are also market abuse and securities fraud provisions in U.S. law just as there are about to be here under the market abuse regime. So I think when you have the IOSCO principles, the existing mechanisms, and the ability to punish market abuse, you have a framework that really works. And that gets me to a further point, and I didn't start myself much, so it's just got off for over 10 minutes. The existing mechanisms in place in a jurisdiction like the US, for instance, but in other jurisdictions around the world too, I don't think create the impetus to enact legislation. And it's one of the issues, and one of the few issues we have with the scope of this proposal. If you talk about a third country regime, you're talking about an instance where the EC may say, well, the EU ultimately say, well, you need to prove equivalence. Well, equivalence, if it's actual proof that there's a mechanism that's similar to the IOSCO principles or otherwise, may not exist or may not be that easy to demonstrate because the existing mechanisms may not take on the exact format. There is no plans, as far as I know, in the US, in Singapore, in other jurisdictions around the world, to actually put in place or to affirmatively say that that we are adhering to the IOSCO principles. If others know more than I do in that regard, please let me know, because I haven't heard anything, and we've met with folks and spoken to others. There are a few other specific issues we have. I'll let Dan, just because I'm probably talking too much, speak to the submitter's code of conduct and some of the problems that we have with that and what we think we create a retreat in a lot of given markets. I spoke a bit about the third country regime. I also, we have specific issues with some of the transparency provisions and near real-time disclosure of data. There are intellectual property concerns. There are also practical concerns. A lot of our sources we have agreements with, which wouldn't allow the disclosure of such data. There's also the idea that we have confidentiality agreements in place with a lot of these people. So there are transparency requirements that are practical issues for us. And I would say those all should be considered. And I know they are being considered. I know MEP Bowles, for instance, has talked about transparency and some of the issues around transparency. She's made some statements in her initial report on methodology and the fact that methodologies need to be disclosed. We would also say caution against the need for absolutely real-time disclosure of data. There are a lot of reasons for that. We can talk about it in the Q&A. I just want to move on to what we think is an appropriate response from our perspective from the industry. We are very much in favor of fixing the problem that exists. And we think that that problem in this instance was LIBOR, Euribor, and like benchmarks. And the EC proposal very much traps LIBOR. And if you look at it, it's very much written to address that problem. We think that an approach that fixes the problem that exists and then leaves open the possibility to add other types of benchmarks as necessary. And for other purposes, formally and wholly suggest the IOSCO approach without some sort of attempt to have binding third-party equivalence is the right approach. And if you need to amend legislation later, you can do it. It's an approach on a national level that occurred in the UK. It seems to work. It's the approach we were in Singapore in September. It's the approach that Singapore seems to be taking. The MAS said that that's the approach that they're looking to adopt. And I think you'll see in jurisdictions around the world that that's a more sensible, scaled, proportionate response. And I think if we're talking about proportionate responses, that's really the answer in our view. And again, we are willing to demonstrate that we do what we do well. But we think imposing a LIBOR mechanism on us for the whole range of benchmarks that we produce isn't scaled and fit for us.